Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. Change is in the air in New York as employers in the Empire State are facing several logistical changes in the near future. This week, we get you prepared. First up, potential new restrictions on severance agreements. Epstein, Becker, Green's Drew Ambrose is here to tell us what employers should know about the No Severance Ultimatums Act, currently awaiting Governor Hochul's signature.
There are a few things to know about the No Severance Ultimatums Act. The first is that it does not have an age restriction on it like the current law does. It does provide now for everyone a 21-day period to review a severance agreement, and then a 7-day revocation period after it has been signed by the employee. The agreements also have to explicitly state that the employee has the right to consult counsel. The employer should be taking this time to work with their counsel to determine whether or not their severance agreements need to be updated so that way they can hit the ground running once this bill does become law.
Thanks, Drew. If the governor signs the No Severance Ultimatums Act, it will become effective immediately. So it's important to take a look at those agreements now. Next, New York's Trapped at Work Act is set to take effect December 19th, following the amendments signed in February of this year. The amended law bans stay or pay employment promissory notes, but includes a broad carve-out for financial bonuses and advances of wages. The Act also now creates new restrictions on tuition repayment agreements. Similar to California's stay or pay ban, there are specific repayment obligations which must be in a separate written contract. New York joins California and Connecticut in bans on certain promissory notes. Finally, new rules for the Earn, Safe, and Sick Time Act went into effect last week for New York City employers. The rules reflect the Act's requirements to provide 32 hours of unpaid protected time off to an employee immediately upon hire. Importantly, employers who use an electronic system to share sick leave balances will need to either make the system available to prior employees for 6 months or prepare a sick leave balance statement to share upon termination. That's it for this week. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.